Today we talk about top filing mistakes startups must avoid. First, sloppy awareness of prior art. You are the expert in your space. You ought to know what prior art exists. And if you don't, go do a search. You can do this free at Google Patent or the US Patent Office or the European Patent Office or at WIPO, right? Do your homework or you can risk a rejection. Second, blabbing too soon. If you talk about your invention before you file a patent application, guess what? You may have lost all international patent rights. Fortunately, in the US, there's a 1 year grace period, but you shouldn't rely on the grace period. You should keep it secret until you file. The filing could be simple. You could use a provisional patent application or ask a lawyer to help you do this very inexpensively. NDAs are your best friend. If you have to talk about it, then get a confidentiality sign. Talk to your investors. If they're not willing to sign an NDA, then keep the discussion at the business level and don't go in depth about how you do it. Same thing with your vendors. Your vendors should have no problem signing NDAs. And if they do, then find somebody else who will. Investors, that you may not have a choice, but I already told you how to handle them. Don't show them secret. Just talk the business principles. Number 3 is vague patent description. Details are important. If you give them a one-pager patent application, guess what? The odds are everybody else trying to solve your problem, they probably have thought about your approach. Now, if you provide lots of detail, 40, 50, 100 pages in depth, nobody is going to do the same invention that you have implemented if you have 100 pages of describing exactly what you're doing, right? So details help you differentiate against unknown prior art. And that, to me, is the most cost-effective way of dealing with the unknown prior art. Don't remember, the details can be text, it can be pseudocode, it can also be drawings. Remember, the pictures are worth 1,000 words, so give a lot of figures. If you're a mechanical person, if you have a mechanical invention, then provide lots of diagrams that, exploded diagrams, side view diagrams, subcomponent diagrams. Show it in every possible angle. If you are an electronics person, throw in the electrical diagram, and then if there's any code necessary, put in the code, the pseudocode for it. If you're a software company, throw in a lot of flowcharts or pseudocodes of how it works. The more description, the better. Clear drawings equals stronger protection. Do not file for the wrong patent type. That's number 4. You need to understand the differences between a utility patent versus a design patent versus a plant patent. A plant patent, of course, cover plant. And most of the startups that I deal with, except in ad tech, they don't deal with, the plant patent. Most patents have to consider between utility and design patent. So a design patent, like the name indicates, covers the aesthetic, the look of it. So an example might be the Coke bottle with the ridges on the length of the bottle. So that's a design patent. A user interface like this is covered by a design patent. The shape of this phone is also covered by a design. Note the curved edges. Apple has successfully received billions for that in a lawsuit. The utility, on the other hand, covers software, covers mechanical devices, covers electrical devices, covers how things work. And so that's the difference between utility, design, and sometimes you want to file both. Number 5 is forgetting global patent protection. Well, the U.S. and Canada patent applications are no-brainer because they're low cost, they cover a large market. But you need to also think bigger picture. Are there uses of your software in Europe or in China? Those are the big markets. And then you have Korea, you got Japan, you got Australia, you got Brazil. So you can go down that path. The list of countries that you file in depends on your particular technology. If you have a technology that's focused on very high-end, expensive items, then you want to focus on the industrialized country. If your invention addresses a very inexpensive way for a core personal need, then consider it more along the developing countries, right? Number 6 is messy records. You need good documentation or you lose everything. Good records turned out to be worth $750 million for Carnegie Mellon in a litigation. So keep records well organized. And then that information, you can transfer that to lawyers so that they can file the application in a good way for you. Number 7 is don't do it yourself, or DIY disasters. Patenteese is a real language, and you need to describe the patent that meets what they call Section 112 requirement. It meets the sufficiency so that somebody's skill can implement. It needs to define the language, the terms used in the claims, and also you need to claim in such a way that you avoid certain art units that would be harder on you. So, for example, the business method, the allowance rate in the business method is significantly lower than those in, let's say, mechanical art unit. So if you use the right terminologies in how you describe the patent application, you can dodge that bullet. So don't let these mistakes kill your startup dream. Protect your ideas like a pro. Hire a Patenteese to be your professional representation in the patent space, and you will do well. We look forward to talking with you. Go visit patenteese.com.